I'm Morgan Cloud. I'm a professor at the law school, and for many years, my teaching and writing has overlapped with the topics of our first session of this really interesting three-day conference. When I tried to think about how do you introduce a discussion of U.S.-Mexico border drugs, rule of law issues, it was overwhelming. So I'm going to introduce, while our folks are working there, I'm going to change the subject for a minute. I hope you all know there's going to be simultaneous translation. We have translators working back there from Spanish to English, English to Spanish. I believe there'll be a headset there for everyone. And as I talk, my comments should be being translated into Spanish, in which they will be just as unintelligible as they are in English. And when our speakers, we have speakers who will present in Spanish. Those of us who are English speakers have the headsets that I believe, to listen to Spanish to English, we set on number 1, and then we can listen and get the simultaneous translation. I'm going to introduce the subject matter of our discussion with just a description of an Emory course that is coming. Next semester, for the first time, Emory University is going to have a course called the University Course. And then, like a professional article, there's a colon with a subsidiary title. In 2011, the course is the University Course, Methland. It's going to be taught by professors from all units of the university, with students enrolled and getting credit from all units of the university. And this is because the problems that we were talking about today are so broad, so intertwined, that it's impossible to understand them by looking only at law enforcement or immigration policy or rule of law concepts. But instead, we have to take into account the behavior of government, law enforcement, and not peripherally the behavior of private sector economic entities like big pharma companies and big agribusiness companies in this country and around the world. And that's what this course is going to do. It's going to address the issues of this panel by looking at it from a range of very difficult perspectives. And I think we'll get a small replica of that today with our various speakers who are going to address different elements of the incredibly complicated, difficult, and seemingly intractable problems that face Mexico and her relationships with her neighbor to the north, and vice versa. Our first speaker this afternoon is Enrique Barber, who is the Chief of Staff for the Attorney General in Mexico. He is a graduate with a law degree from the Autonomous Technological Institute of Mexico and has an LLM from my alma mater, Cornell Law School. He teaches in Mexico and has been a visiting professor at other fine law schools like the University of Georgia Law School. He teaches constitutional law at the ITAM Law School and is a member of the Academic Evaluation Committee of the National Council for Science and Technology, and has authored various works on constitutional and administrative law. Since I'm now about a fifth of the way through his bio, I think that you get the sense that this is a distinguished, talented, and accomplished man, and we look forward to hearing him. And again, would you like, you can speak from there or you can speak from up here. What's your preference?
Same thing, you tell me.
What you prefer?
Muy buenas tardes a todos. En nombre de la Procuraduría General de la República, agradezco al profesor David Bartlett, director de la Escuela de Derecho de esta prestigiada Casa de Estudios, al doctor José Antonio Lozano, director de la Facultad de Derecho de la Universidad Panamericana, así como al profesor Paul Swire, su muy amable invitación para compartir algunas reflexiones con todos ustedes. el Procurador General, Arturo Chávez, es un entusiasta promotor de la adopción del y de la transición hacia el sistema de justicia penal acusatorio oral. Lamenta mucho no poder estar hoy en Emory y por eso me pidió transmitirle sus saludos afectuosos y su enorme interés por los temas que aquí se aborden y por las conclusiones a las que se arribe. Como todos ustedes saben, el 18 de junio de 2008 se publicó en el Diario Oficial de la Federación, el órgano oficial de difusión del Gobierno federal e incluso de los poderes legislativo y judicial, el decreto por el que se modificaron diversas disposiciones de la Constitución Política de los Estados Unidos Mexicanos para, entre otras cosas, adoptar un nuevo sistema de justicia penal de corte acusatorio y oral. No se trató de una medida propuesta o impulsada de manera aislada. Por el contrario, forma parte de una estrategia integral puesta en marcha desde diciembre de 2006 y que va mucho más allá del combate al narcotráfico. El objetivo final es la consolidación del Estado de Derecho, de la cultura de la legalidad y, por supuesto, de la aplicación de la ley y del combate a cualquier expresión delictiva, pasando, por supuesto, por la lucha frontal contra la delincuencia organizada. Tal estrategia, diseñada e instrumentada por el Gobierno federal, se integra por objetivos y acciones agrupados en diversas etapas. La primera de ellas, y que se tradujo en la de mayor urgencia, fue contener el avance de las bandas delictivas. Para lograrlo, ha sido necesario emplear toda la fuerza y toda la inteligencia de que disponen las instituciones para detener a los delincuentes y desarticular a las organizaciones, y posteriormente para vulnerar sus estructuras financieras y su poder económico. Los resultados de este pilar de la estrategia mexicana por la legalidad, el Estado de Derecho y la seguridad pública no tienen precedente. Durante la administración del presidente Felipe Calderón, se ha detenido a más de 115,000 personas relacionadas con delitos contra la salud. Se han asegurado más de 84,000 armas de fuego y 8 millones de municiones. Se han desmantelado más de 400 laboratorios, se ha privado a los criminales de más de 330 millones de pesos y de 415 millones de dólares, y también han pasado al Estado más de 34,000 vehículos. Como segundo eje de la estrategia, se ha emprendido un trabajo serio y comprometido de fortalecimiento institucional para asegurar que el país cuente con instituciones fuertes, confiables, transparentes, con servidores públicos profesionales y especialmente capacitados, con atribuciones y facultades pertinentes para hacer frente a la delincuencia organizada que afecta a muchos países. Esta decisión se fundó en la convicción de que ante la situación de violencia, de inseguridad y de impunidad que afecta al país, lo peor que puede suceder, lo más riesgoso para todos, sería la inacción, la pasividad y la resignación. Si el sistema no funciona, la obligación de los poderes y órganos del Estado, así como de los actores políticos, es simple y sencillamente cambiarlo. Por ese motivo, el Gobierno federal propuso y el Constituyente permanente aprobó una serie de modificaciones institucionales de gran calado. Destaca, en primer lugar, la reforma al sistema de justicia penal. Sin temor a equivocarme, puedo decir que el tránsito del sistema penal inquisitivo mixto a la justicia criminal acusatoria, adversarial y oral constituye el cambio más profundo a nuestro sistema procesal penal en la última centuria. Con este cambio, dispondremos de un sistema de justicia criminal regido por los principios de inmediación, contradicción, concentración, presunción de inocencia, transparencia y oralidad, que sin duda mejorará la calidad, la confiabilidad y la credibilidad de nuestras instituciones de seguridad pública y de justicia. Del mismo modo y con el mismo espíritu, el Congreso de la Unión ha expedido nuevas leyes para fortalecer y organizar las funciones del Sistema Nacional de Seguridad Pública, de la Procuraduría General de la República, del Consejo de Seguridad Nacional y de la Policía Federal. Ahora, las instancias de la Administración Pública Federal y la propia Procuraduría General de la República despliegan esfuerzos permanentes para consolidarse, profesionalizarse, robustecer sus capacidades, adquirir experiencia, coordinarse efectivamente, optimizar sus recursos y ofrecer a los ciudadanos cada vez mejores resultados. Como tercer punto, la estrategia gubernamental plantea el restablecimiento del tejido social, partiendo de la conciencia de cada cual de respetarse a sí mismo, respetando los derechos de los demás, de la formación de una nueva generación de ciudadanos con principios y convicciones inconmovibles, así como de la generación de más y mejores oportunidades de desarrollo y crecimiento en las comunidades del país. El objetivo final de las acciones del Gobierno de la República consiste, como ya lo anticipé, en consolidar la cultura de la legalidad, el imperio de la ley, en abatir sensiblemente la impunidad, en combatir frontalmente cualquier expresión criminal, incluyendo a la delincuencia organizada, y de esa manera garantizar la seguridad y la integridad física y patrimonial de los mexicanos. Ahora sí, volviendo al tema que a todos nos interesa y por el que estamos aquí. En términos de lo que dispone el régimen transitorio del Decreto de Reformas Constitucionales sobre el Sistema de Justicia Penal, la Federación, los Estados y el Distrito Federal disponen de un plazo perentorio que fenece el 19 de junio de 2016 para expedir la legislación secundaria que sea necesaria y que corresponda para iniciar la operación del nuevo sistema. A partir de las resistencias naturales, de las dudas y la incertidumbre, de la inercia e incluso de la franca oposición de algunos operadores de la justicia penal, a lo largo de los 28 meses que han transcurrido desde la publicación del decreto, los esfuerzos y los avances son indudables. Por ejemplo, se constituyó el Consejo de Coordinación para la Implementación del Sistema de Justicia Penal, integrado por representantes de todos los poderes de la Unión, así como de las entidades federativas y de las organizaciones civiles y académicas. El Consejo se conforma con los secretarios de Gobernación y de Seguridad Pública, el consejero jurídico del Presidente de la República y el Procurador General de la República, con un representante del Senado de la República y otro más de la Cámara de Diputados del Congreso de la Unión, con un ministro de la Suprema Corte de Justicia de la Nación y un representante del Consejo de la Judicatura Federal, así como por quienes representan a las conferencias nacionales de secretarios de Seguridad Pública, de Procuración de Justicia y de Tribunales Superiores de Justicia. En prácticamente 2 años de trabajo, el Consejo ha aprobado y emitido los programas de capacitación para los operadores del nuevo sistema de justicia. Ha distribuido con el mismo fin recursos presupuestales a las entidades federativas e incluso ha concluido un proyecto de Código Federal de Procedimientos Penales que próximamente será sometido a la consideración del propio Congreso de la Unión. Concretamente, la Procuraduría General de la República se ha asumido como promotora decidida de la importancia y de la necesidad de transitar hacia el nuevo sistema de justicia penal. De manera directa, a través del Instituto Nacional de Ciencias Penales, que es un organismo público descentralizado, sectorizado en la Procuraduría, que tiene como mandato principal la formación inicial y la capacitación permanente de los agentes del Ministerio Público de la Federación y de los peritos profesionales, e incluso con el apoyo de los Estados Unidos a través de la Iniciativa Mérida, ha impartido más de 50 cursos de capacitación especializada sobre el nuevo sistema, ha construido 3 salas para capacitación, ha organizado 6 congresos internacionales sobre el tema, ha publicado 6 libros y más de un centenar de artículos de divulgación y lleva a cabo 22 investigaciones técnicas sobre la reforma penal. Por otro lado, y en relación directa con nuestra responsabilidad de investigar y perseguir los delitos federales, la Procuraduría también ha desplegado importantes esfuerzos en esta etapa de transición. El Procurador expidió y publicó, entre otros, el acuerdo por el que se establecen lineamientos para la preservación del lugar de los hechos o del hallazgo, huellas, indicios y evidencias, lo que comúnmente conocemos como la cadena de custodia. Podrá parecerles extraño, pero hasta comienzos de este 2010 no existía en México un instrumento jurídico similar. Por supuesto, fue necesario iniciar de manera inmediata la capacitación de nuestros agentes de la Policía Federal Ministerial, de nuestros peritos e incluso de la propia Policía Federal, de las policías estatales y municipales, hasta llegar a las Fuerzas Armadas. También se instituyó el registro administrativo de detenidos, que constituye no solamente una base de datos fundamental para generar inteligencia, sino que es un verdadero derecho fundamental de los probables responsables de la comisión de algún delito, pues la información sobre su detención y sus aprehensores, así como sobre su situación jurídica, estará disponible prácticamente en tiempo real y ello evitará arbitrariedades y otras conductas indebidas e inadmisibles. En consonancia con las mismas reformas, la competencia para prevenir, investigar, perseguir y sancionar el narcomenudeo ya no corresponde a la Federación, sino a cada una de las entidades federativas. Por ello, se trabaja en nuevos esquemas de colaboración entre ambos órdenes de gobierno, como capacitación, entrenamiento, así como la constitución y puesta en marcha de centros de operación estratégica que permitirán la actuación coordinada entre las autoridades locales y federales, la generación de información conjunta y el intercambio de inteligencia. Por otro lado, el arraigo es un instrumento constitucional invaluable en la lucha contra la delincuencia organizada, aunque soy plenamente consciente de que existen numerosos cuestionamientos en torno a sus implicaciones frente a los derechos fundamentales de las personas. No siempre resulta sencillo explicar que, a diferencia de una investigación que concluye en una detención, el arraigo permite una detención, sin serlo formalmente, para perfeccionar o integrar una investigación. Al respecto, conviene decir que en una situación tan grave como la que afecta a México actualmente, es indispensable dotar al Estado de más y mejores instrumentos para proteger la integridad y el patrimonio de sus ciudadanos. Sin el arraigo, resultaría muy difícil, por ejemplo, ejercer la acción penal o consignar a un conocido probable responsable que hubiese sido detenido en flagrancia, portando una o varias armas de fuego de uso exclusivo de las Fuerzas Armadas, como resultado de un operativo de prevención practicado, digamos, por la Policía Federal, por delitos distintos a la propia aportación del arma. Si esa misma persona fuese arraigada, existen elevadas probabilidades de que al declarar ante el Ministerio Público refiera dónde adquirió las armas de fuego, quién se las entregó, para qué o contra quién las utilizaría, en qué plazas opera, a qué actividades se dedica, bajo las órdenes de quién actúa, qué otros delitos ha cometido, en fin. Con ello, podría iniciarse una investigación conducida por el Ministerio Público y a cargo de la policía, practicarse cateos, intervenir válidamente comunicaciones privadas y llevar todo ese cúmulo probatorio, buena parte de él obtenido a través de medidas y actuaciones sujetas a control judicial, ante los órganos jurisdiccionales competentes. De otra suerte, como saben, la investigación para la prevención no arrojaría evidencia judicializable y plenamente útil en el proceso penal. Lo mismo podría decirse de la persona que es sorprendida, por ejemplo, por agentes de aduanas o de la Policía Federal al desembarcar de un vuelo en el Aeropuerto Internacional de la Ciudad de México y transportando en su equipaje, digamos, $500,000 en efectivo. Sin el arraigo, el Ministerio Público no tendría otra alternativa que ordenar, cuando mucho, su retención por 48 horas, integrar una averiguación previa a partir de los elementos de prueba derivados de la detención en flagrancia y quizá, utilizando la declaración del indiciado, y entonces ejercer la acción penal ante un juez por el delito de contrabando. Mediante el arraigo, sería factible obtener mucha más información adicional para sustentar una investigación de espectro mucho más amplio. ¿De qué actividades proviene el dinero? ¿Por cuenta de quién lo transportó al país? ¿Cuál sería su destino? ¿A quién y para qué lo entregaría? ¿Cuáles son sus vínculos con grupos criminales nacionales o extranjeros? ¿Cuál es su posición dentro de la organización delictiva? ¿Cuánto dinero transportan al país mensualmente? Así como realizar pruebas forenses de eventuales equipos de comunicación y de cómputo, patrones de viajes al extranjero y patrones de declaración de efectivo entrante o saliente, o solicitar, por ejemplo, la colaboración o la asistencia jurídica de autoridades extranjeras. Además, contra lo que muchos suponen o piensan, el arraigo no es una herramienta de naturaleza administrativa ni se encuentra a la disposición discrecional del Ministerio Público. Se trata en realidad de una medida cautelar que el propio fiscal puede solicitar a un juez de garantías o especializado en cateos, arraigos e intervención de comunicaciones, aportando los elementos y medios de convicción necesarios y que establece la propia Constitución. Al concluir el arraigo, el Ministerio Público debe informar al propio juez el resultado de la investigación y la situación jurídica del arraigado. Se trata de una medida extraordinaria para hacer frente a la delincuencia organizada. Por ello, los resultados en torno a la utilización del arraigo, lo que en la Procuraduría llamamos la eficacia del arraigo, resulta elocuente. Entre 2008 y lo que ha transcurrido de este 2010, en más del 94% de los casos, al concluir el arraigo judicial y ejercerse la acción penal, los tribunales federales han librado órdenes de aprehensión solicitadas por el Ministerio Público. Una vez ejecutadas tales órdenes, los jueces han dictado autos de formal prisión en más de 9 casos de cada 10, y en un porcentaje también superior al 90% se dictan sentencias condenatorias. En todos los casos, los jueces que conceden o niegan la medida cautelar de arraigo conocen las constancias de la averiguación previa y, una vez fenecido dicho arraigo, reciben un informe sobre los resultados de la investigación y la suerte procesal del arraigado. Ello es muestra clara de que el Estado mexicano no ha abusado del arraigo para privar ilícitamente de la libertad a ciudadanos inocentes. Por el contrario, ha hecho un uso responsable de esa figura que el propio Poder Revisor de la Constitución ha puesto a su alcance como un medio eficaz para dar la batalla contra la delincuencia organizada. Permítanme volver al inicio. Comencé señalando que la crisis de violencia que vive México existe propuestas y soluciones nuevas, porque es un problema inédito y que lo peor que el gobierno puede hacer es no hacer nada. En México, el gobierno federal celebra y felicita a los 8 estados que ya han puesto en marcha, de manera gradual, el sistema de justicia penal acusatorio y oral. La experiencia ha enriquecido cada una de esas transiciones y, sin duda, deberá orientar el camino federal. Por supuesto, en la ruta ha habido errores, omisiones e incluso confusiones que han generado fenómenos tan indeseables como la llamada puerta giratoria, que alarmó a la autoridad y sobre todo indignó a la sociedad. Por ello, la Procuraduría General de la República ha iniciado un análisis muy profundo y serio en relación con el proyecto de Código Federal de Procedimientos Penales. Como institución constitucionalmente responsable de la investigación y de la persecución de los delitos federales de cualquier tipo, los temas en los que el Ministerio Público de la Federación ha puesto especial énfasis y ha abierto el debate y la reflexión más profunda en torno a sus implicaciones y consecuencias son los siguientes. La posibilidad de que la acción penal se ejerza de manera privada, eliminando el monopolio que hoy corresponde al Ministerio Público. El alcance de los criterios de oportunidad en la actuación del Ministerio Público, específicamente en casos de delincuencia organizada. Las implicaciones de la justicia alternativa. Los plazos para llevar a cabo y concluir la investigación formalizada, una vez realizada la imputación formal del Ministerio Público y celebrada la audiencia de control de detención, imputación y medidas cautelares. Los alcances y efectos de la prueba de referencia, la conocida como hearsay. La posibilidad de solicitar salidas alternas al proceso penal, como el procedimiento simplificado, el procedimiento abreviado, los acuerdos reparatorios, la sentencia anticipada, entre otros, por operadores distintos al Ministerio Público, y la institución de medios de impugnación limitados, como la casación, frente a la apelación, así como el alcance de las determinaciones o resoluciones de los tribunales de segunda instancia. En la Procuraduría General de la República estamos convencidos de que el nuevo sistema de justicia penal brindará a todos muchos mejores resultados que nuestra justicia penal actual, basada en un sistema inquisitivo mixto que ha dado al Ministerio Público facultades tan amplias como ineficaces. Es claro que la instrumentación del nuevo sistema de justicia debe partir de 2 principios esenciales, la integralidad y la gradualidad. La aplicación debe ser integral para que ninguna conducta quede fuera o excluida del ámbito material de validez del sistema, sin importar su gravedad. Esa misma integralidad implica que la capacitación y el compromiso deben abarcar por igual a las policías, al Ministerio Público, a los defensores, a los jueces y a los tribunales, a los peritos e incluso al personal penitenciario. La aplicación al mismo tiempo debe ser gradual, es decir, debe referirse a ámbitos geográficos en los que ocurra la transición. Por ejemplo, respecto del Código Federal de Procedimientos Penales, debe partirse de circuitos judiciales específicos, con las características que establezcan los operadores del sistema. Por supuesto, la intención es descongestionar el sistema penal, privilegiando la justicia restaurativa y las salidas alternas al proceso penal. Muchas gracias.
Thank you, and I've been resisting. If you notice on Mr. Barber's name tag, if you see it, it's got the abbreviation for master, and so I promised him I wouldn't call him Master Barber, but it's so hard not to. Thank you very much. Our procedure is going to be this. Each speaker will get 20 minutes, and this is the first time in my history of moderating when I showed somebody the stop sign and he stopped. I'm stunned. I'm speechless. Yeah, he was actually in the last few words, but. And at the end of our 4 speakers, we'll then open this for questions and commentary for you. I'm sure there'll be questions about the current and forthcoming Mexican trial system and criminal justice system that people will have. Our next speaker is an Emory professor. He's Jeffrey Staton, an associate professor of political science. He's got a brand new 2010 book published at Cambridge University Press, with the relatively relevant title of Judicial Power and Strategic Communication in Mexico. He's published widely in various political science, comparative and international law journals on these topics of rule of law and democracy, with some focus in Mexico. He's been a professor at Florida State University, a postdoc fellow at the Center for U.S.-Mexican Studies at UC San Diego, and at NYU Law School. He's got his PhD from Washington University in St. Louis. Jeff?
Just have to open up my show. Okay, thank you very much for the opportunity to speak with you this afternoon. I'm actually humbled by this opportunity. I'm looking forward to learning a great deal about legal reform in Mexico and its relationship to the drug trade over the next few days. Indeed, we're going to be hearing a wealth of highly detailed analysis of both topics over the next couple days. And I think I was asked to give a more general introduction to the subject of the rule of law reform internationally, and so that is largely what I'm going to try to do the next few minutes. You know, there are a number of institutional challenges that political institutionalists are commonly confronted with that are relatively easy. For example, society has a sense that the results from elections are just highly disproportionate. We can relatively quickly give you an electoral rule that'll sort out the proportionality of those results. If you want to lock in some sort of fundamental commitment to a new policy reform, we can suggest constitutional terms that will make it very hard to change the status quo. What we're talking about here over the next couple days is what I think about as probably the most fundamental problem of institutional design. Human beings have known about this problem for centuries. And so what I want to do by way of kind of framing my remarks is just lay out what that problem is as follows. And so this is from the 51st Federalist, right? The problem is simple, right? And in framing a government which is to be administered by men over men, the great difficulty is the following trade-off. How do you enable the government to control the governed? And simultaneously, how do you get it to oblige itself to control itself, right? That is the challenge, and the subject of rule of law reform in the context of narco-trafficking in the United States and Mexico confronts this trade-off directly in many, many ways. In terms of thinking about controlling the governed, the general sense of a public security problem itself is about thinking through how to empower the state to control us. Dealing with that where there's a sense of among the public that there is great impunity, certain classes of people can commit crimes and not be brought to justice. That's calling for an empowerment of the state. Doing it where there's a lack of generalized trust for the elements of the security sector or for pieces of the judiciary, again, calls for a kind of empowerment of government. Yet at the same time, we know that there are concerns that the state cannot control itself from violating individual rights. So the concerns I think we're going to hear about over the next couple days that deal with obvious due process violations or violations of international human rights norms, concerns over prosecutorial discretion, concerns regarding the lack of independence among prosecutors and the judiciary. Pieces of this reform we've been talking about have been designed to address both sides of this trade-off. But it bears repeating, it is a trade-off. And I think it's important to keep that in mind as we think about the impact of these reforms. When you confront such a trade-off, it may not be possible, right, to maximize both dimensions simultaneously. You have to make a choice about the kind of state that you want. So in the remainder of my time, let me talk a little bit about what my goals are in light of that trade-off. The first is to sort of review a little bit about what we know about the rule of law so that at least for the next couple minutes, I will share a common vocabulary with you. I'll say a little bit about what effects we know flow from elements of the rule of law. Then I want to spend, I hope I will have the time to say something about some empirical findings which I find quite vexing In particular, they raise questions about our capacity to intelligently and successfully reform the rule of law, even if elements of the rule of law have really good effects. And finally, I'll spend a minute time talking about some implications of those findings for what we'd like to do in terms of reform. The bottom line here, and again, this is in part an academic point, but I hope that it is meaningful for policy reformers. We need a better, more coherent strategy of research design, and I mean that from theory to the empirical designs we choose to track and evaluate and ultimately make recommendations about reform. It doesn't mean that we stop reforming. I think human beings reform themselves, largely speaking, without, in many ways, without the science to back up precisely what the effects of the reform would be. But it seems quite silly that we have the capacity to do that science well, and we're not. And that's, frankly, a statement on me as much as anyone else, and the folks who do work like I do. Okay, so what do we know? What do we feel pretty comfortable about knowing what the rule of law is? We know we can measure it, more or less, validly, and that elements of the rule of law have some nice causal properties. So defining the rule of law in legal philosophy is, there are reams of paper devoted to battles over its concept, but for the most part, we kind of have a sense of what it is, right? I mean, it's, and this is drawing from Raz's work in the 70s. It means two things. One, that people should be ruled by law and obey it. And secondly, that law ought to be such that people can be guided by it. That's a very thin concept of it, and what philosophers typically do at that point is think, okay, well, what properties of law would help us do the second bit up here? That is, allow people, and that is individuals and members of the state, to be guided by it. And so then we get this list of properties. And so this is the list. This is a list. It's a pretty common one, just so we're talking about things in the same way. And I think pieces of this list find pieces of the legal reform were designed to advance pieces of it, right? That's not a very elegant way of saying that. But the law ought to be transparent, right? There ought to be some commitment to some sort of procedural fairness, that judges and prosecutors ought to be independent of their appointers. There ought to be minimal discretion in prosecuting. Law ought to be stable, accessible. And judges ought to have the power of judicial review so that the state can be accountable to their own limitations. This is sort of the elements of the rule of law that I think, for the most part, we would share. Okay, so this much, conceptually, we're sort of on the same page here. I'm going to spend in the empirical portion a little bit more time focusing on transparency and independence relative to these other dimensions. Okay, we can measure it. This is the world. It's a map. This is a measure, well-known measure from the World Bank in 2005. There are plenty of concerns about whether this measure induces a valid measure, right? But for the most part, there's a reasonable amount of evidence that we can do this validly. That is, in some general sense, this map says something reasonable about rule of law values around the world. Third, we know the rule of law, or elements of it, has some important effects. So most obviously, studies have shown that effective legal institutions are very useful for ensuring, and by effective legal institutions here, one feature of an effective legal institution is an independent judiciary. It's very useful for ensuring state solvency, for producing growth and trade and development. More recently, we've turned to looking at the effects of judicial independence on order in democracy. So what role does an independent judiciary have in ensuring that democratic regimes are stable? So this picture summarizes some of what we've been finding. So this dark line here, where's my thing? That's the estimated change in the expected number of years a democracy is believed to survive, associated with a one standard deviation change in judicial independence. These bars here represent confidence intervals around the change. And so and this is across the level of development of a country. Down here, relatively underdeveloped countries, and these are relatively developed ones. And so you want to take away two things from this figure. One is that once a country has crossed a certain threshold of development, we find there actually is a pretty significant positive impact of reforming a judiciary, making it more independent, making the system itself better, right? But down here, in underdeveloped countries, there really isn't any effect. You can grind away at institutional reform you want, and you're not going to cause any change. Now, this is where Mexico is. Mexico sort of sits in the piece of the graph where if you got the reform right, at least at the study, if you buy the study, That's another talk. There's an effect, a meaningful one, on the stability of democracy. In fact, that's an estimated change of about 50 years, all right, on the survival of a democracy associated with a 1 standard deviation change in independence derived from the study. So here's what's less clear. And it's a big thing, or a set of big things. What's less clear is how do we get from a dependent judiciary or the lack of the rule of law to the rule of law through institutional design. And by implication, that is, how do we design these little elements, right, of the rule of law? By implication, how do you design your way to the rule of law itself? So a couple basic questions I want to review here are as follows. First, what do we know about the basic effects of the formal rules that are supposed to incentivize judges to behave independently or prosecutors to behave independently on their behavior? Like, what does that look like? Okay? And secondly, I want to spend just a second talking about transparency. Does transparency, does providing more information to the public, right, does it increase beliefs in the legitimacy of our system? Right? Those are the two questions. So the first one, the claim is we know how to, through things like lengthening tenure, disconnecting one element of the government from others in the appointment process, making it hard to remove judges, all the kind of the rule of law menu for rendering judges independent. Can we incentivize them to behave that way? So what this picture shows is a bunch of correlation coefficients. The x-axis is a measure of the formal rules that are supposed to incentivize judges to behave independently, derived by a Mexican legal scholar, Julio Rios Figueroa. And on the y-axis, these are just various measures of the actual behavior of judges, and this is basically for a sample of the entire world, okay? I'm sorry, this is Latin America, pardon me. From 7 different places, measures that have been developed in Europe and in the Americas. And so we see up here this couple kind of positive coefficients, right? But if you drop down and look, these are really small numbers, okay? So it's positive, but really moderate. These numbers are negative. That is, get the incentives right so they behave independently, they're less independent. Most of the data sits sort of in the center, which is around 0. And I just don't think you can have a conversation about rule of law reform without confronting these data, right? We find either very small effects or no effects everywhere we look, okay? This is from a study, an international study of prosecutorial independence conducted by 3 German academics. And this is the zero-order correlation between rules that incentivize prosecutors to behave independently of the state and their actual behavior. And that correlation is negative 0.20. So if anything, you make them incentives for more independent behavior, they behave less independently. It's at very least puzzling, in my view. So what explains the findings? Well, one possible answer is we reform precisely where the problem is the worst. So it will look like in observational studies like there's nothing, right? But that would suggest that we sought to see a change over time, and we don't. Another possibility is the institutions don't matter. What matters is political context, some element of public support, the professionalization of the people in these positions, their ethics, the resources we throw at them. Right? That's a possibility. If that's a possibility, we might as well close the conference down, right? If that's true. And I kind of have the sense that that's probably not right. The third possibility, and this is what I actually believe, is that the institutions that we design, a single institution, can have 2 competing effects, all right, on the same person's behavior. They set up 2 countervailing incentives, and so you may have different effects on different people. Let me give you an example. Consider increasing the tenure of a person, a judge, right? What is that supposed to do? Well, commonly, our 19th century sense of what that would do, or 18th century sense of what that would do, is it makes a judge feel like, well, I don't have to worry about my future and my future job opportunities. I can concentrate on my work now. So it induces less deference and more independence, more autonomy, whatever. That's the story. But by simultaneously increasing tenure, right, by doing that, you also increase the stream of benefits that come to a person by holding that post. And judges, in particular in Latin America, get removed both for constitutional and metaconstitutional reasons all the time. If that's true, then you simultaneously incentivize them to be more deferential and more careful. Okay? Am I at 15? Okay. The last thing I'll talk about, yes, great. The last thing I'll talk about in terms of the empirics of this is the idea of transparency, and that transparency is always a good thing, okay? So the claim here that comes from international legal scholarship is basically characterized by the following statement: to know a court is to love one. That is, you provide more information to people about what judges and lawyers and prosecutors do, and they will like the system. And the reason is that, in particular, I'll speak with respect to judges, that they engage in very detailed technocratic decision-making. In some places they wear robes, they're often elevated, they communicate a myth, right? The story goes of impartiality. Whatever they're doing, right, they communicate that through the way that they do it, and that's different from routine political deliberation, okay? So what have people found when they looked at that? That would suggest that the way we get to legitimacy among the public is to provide more information. So what have we found? This is a study of 18 countries in Europe and the Americas, public opinion surveys in each of them, okay, where they're estimating out of those surveys the effect of making someone more aware of their high court. They're either their Supreme Court with constitutional jurisdiction or their constitutional court, okay? What's the effect of making them more aware on their perceptions of legitimacy in that court? And if you just look at the zero-order correlation, pretty much everywhere, it's positive. That is, give people more information and they love the court, okay? There's 3 countries where that wasn't true. Notably, one of them is Russia. If you simply control for how the respondent feels about the policies that come out of the court, that is, do you like what the court does? And you ought to control for that, because when people like what other folks are doing, they often pay more attention to them, right? So you may attribute the effect of just liking what the court's doing to becoming aware. When you just control for that, the result goes away in over half the cases. So it's not the case that making someone aware of a court doesn't make them like it more. In fact, in the United States and France and Great Britain, that works, right? It's just that it doesn't work everywhere. So the question is why? And so what we've recently suggested is that what's going on is that, yeah, sure, awareness can be correlated with legitimacy, but only if people are actually exposed to judicial behavior that conforms to rule of law values. You give people information about judges who they can tell a story that's very partisan in nature, right? Or they can tell a corruption story. They don't update positively about that court. So empirically, this is what we find. This line here is the expected effect of awareness on legitimacy, with confidence intervals around it, across a measure of the rule of law. So this would be like France and the United States, and that's where we see that positive effect. But down there, in places where the rule of law is compromised in a number of ways, the effect's negative. You give people more information about their judiciary, they will think badly about them, okay? I actually I've done a lot of my work on the Mexican federal judiciary, and I have the utmost respect for the people in the Mexican federal judiciary and the work that they do. That said, given the role of the conference and what the study is suggesting, this is where Mexico is on this particular measure. It's right on the borderline of like a negative effect or basically nothing, okay? That's the predictive effect from that particular study. And I think that has an important implication, which I'm going to get to now in my conclusions. Okay, so the first implication I see out of this is if the Federalist 51 trade-off is right, if that's really the kind of problem that we're dealing with, a problem of energizing government on one hand and constraining it on the other, then you will almost necessarily result in institutional design features that are at cross purposes with one another. You have to. It's impossible not to. We heard an analysis of one form of institutional reform in Mexico just a few minutes ago that is dealing with, trying to deal with both sides of that problem. That in some ways is going to mean we're going to be frustrated with the results of our reform if you have one vision of what needs to be reformed and someone has another, right? More importantly, at least from my view, we absolutely have to have better theoretical and empirical program for evaluating our reform effects. If institutions really do have different effects on the same people, you will not learn about them by doing observational studies, say by comparing Chile or Colombia to Mexico on real data. You won't see it because the effects cut differently inside a single person's head. That means we have to be funding laboratory analysis. We just absolutely have to. Finally, and this is the last bit, and I think this sort of I'll draw back to the notion of these transparency results. The effects that we expect our institutional reforms to have really depend on the context in which we drop them. Okay, I think that's a generally understood sort of idea. The effects of transparency that we're finding reinforce that. It means that if you just expose people to information, but other pieces of the reform are not yet moved yet, right, and not yet really operating, you may not get the outcome that you expect. It's not because the reform isn't doing any work. It is. It's just not coordinated with all the other pieces of the reform. At the very least, it means you have to ratchet down your expectations, right, about what you think this kind of legal reform can do. So with that, I'll stop. Thank you very much.
I'll work on that. Okay. See if I can get out of there. So this is really disconcerting. I've got somebody who finished 30 seconds early. I don't know how to handle this group. Already you can see the possibilities of provocative discussion here are tremendous. Enrique Barber talked about this extensive, ambitious, lengthy, over many years, effort in Mexico to reform justice structures. And then Jeff Staton gets up and tells us that I think we might say without the proper social context, these reforms may not have the effects we all hope they do. So this is already, we've got some very fundamental issues about which to speak when we get done. Our next speaker is Luís Astorga, who's a researcher at the Institute of Social Research of the National Autonomous University of Mexico and coordinator of the UNESCO Chair Economic and Social Transformations connected with the international drug problem. He's the member of many academic societies, including the Mexican Academy of Sciences, and has published widely in many countries on many continents about these issues. And just to give you a sense, I'll read the English translations of several of his titles: Drugs Without Borders, The Drug Century, Drug Traffickers' Mythology in Mexico. He has a PhD in sociology from the University of Paris. Luís, are you going to speak there? Or you want to come up here? Okay. I'm just going to turn off that. Are you going to use the computers? We have to figure out how to get rid of Jeff's. Lock, Corky. Do we have an escape? What is escape? This will not.
Bien, muy buenas tardes. Muchas gracias por esta invitación y por la oportunidad de compartir con ustedes estas reflexiones acerca de la interrelación entre el campo del tráfico de drogas y el campo de la política en México en perspectiva histórica. Voy a hablar del sistema internacional prohibicionista que cumplió 100 años el año pasado. Las leyes, el marco legal internacional prohibicionista, cómo se ha desarrollado el campo del tráfico de drogas en México y la interrelación entre el campo del tráfico de drogas y el campo de la política en México, para terminar con algunas de las alternativas que creo yo que tiene la clase política en México en estos asuntos. Bien, el andamiaje institucional prohibicionista empieza en 1909 con la conferencia de Shanghái. Después hay una serie de conferencias más o menos en el mismo tono. La Convención Internacional del Opio en 1912. En 14 la ley Harrison en Estados Unidos. En 1920, después de la Revolución Mexicana, ya una vez terminada la Revolución, la primera ley prohibicionista en México es la ley contra la marihuana, cuyo título era Disposiciones sobre el cultivo y comercio de productos que degeneran la raza. En 1926 viene la ley que prohíbe la amapola en México. En 1937, la Marijuana Tax Act en Estados Unidos, y hasta finalmente llegar a las convenciones de Naciones Unidas de 61, 71 y 88, y también la de 2000 sobre delincuencia organizada transnacional. Bien, este es el marco internacional y digamos el marco prohibicionista en México, en Estados Unidos, y el marco internacional. En los primeros años del siglo XX, del 16 al 20, ya podemos ver una de las características de la relación entre el campo de la política y el campo del tráfico de drogas en México, que estaba en germen. Y esto es que el campo del tráfico de drogas va a estar supeditado desde sus inicios al campo de la política. Es decir, no son negocios que nacieron separados, sino que los traficantes nacieron dependientes del poder político. Y así van a seguir durante toda la época del sistema de partido-estado que se crea después de la Revolución. Hay un intento de ruptura con ese esquema prohibicionista en los años 40, en los últimos años de la administración de Lázaro Cárdenas, y en 1940 México aprueba el Reglamento Federal de Toxicomanía, donde se plasmaban las tesis del doctor Salazar Viniegra, que había sido el encargado de la aplicación de la política sobre drogas del gobierno de Lázaro Cárdenas, y lo que él planteaba era que el gobierno mexicano debería proporcionar la droga a precio de costo a los adictos bajo vigilancia médica, y que además el gobierno mexicano debía crear clínicas en todo el país para tratar a los adictos. El reglamento no cayó muy bien en Estados Unidos, y Estados Unidos decretó el embargo de medicamentos narcóticos a México hasta que México no se retractaba. México se retractó y ese reglamento tuvo vigencia nada más como mes y medio. Desde entonces, México jamás volvió a oponerse de manera frontal a la política sostenida por Estados Unidos. En 47 tenemos que la política de drogas pasa del Departamento de Salubridad a la PGR, y también hay cambios institucionales. Se crea la Dirección Federal de Seguridad en México en 1947, que es, la contraparte de la CIA, y desde un principio tenemos noticias de la vinculación de su creador y de los altos mandos de la Dirección Federal de Seguridad con el control del tráfico de drogas en México, es decir, como mediador, institución mediadora entre el campo de la política y el campo del tráfico de drogas. Las primeras acusaciones fuertes que se hacen en México son contra un gobernador, en ese entonces gobernador de Sinaloa en los años 40, quien había sido secretario de Guerra y Marina, lo que es hoy la Secretaría de la Defensa Nacional. Estas acusaciones se dan de un grupo político hacia otro grupo político, es decir, el grupo político de Lázaro Cárdenas contra el grupo político de Ávila Camacho, del cual formaba parte el gobernador Pablo Macías Valenzuela. Esas disputas finalmente tiene que entrar el presidente Miguel Alemán a parar ese pleito entre familias revolucionarias, y hasta ahí llegó el asunto. En la década de los 60 vamos a entrar a una nueva fase de esta política prohibicionista, no solo con una retórica ya de tipo bélico, esta famosa metáfora de la guerra contra las drogas acuñada por la administración Nixon, y su aplicación práctica, que va a ser la Operación Intercepción en 1969, es un cierre de algunos días, no un cierre, un control más estricto en la frontera México-Estados Unidos para tratar de contener el tráfico de drogas. Por supuesto, sin ningún resultado práctico, pero sí con un resultado diplomático muy negativo para las relaciones bilaterales. De 75 a 78 es el primer gran operativo militar en todo el continente americano para la destrucción de marihuana y amapola en las sierras del noroeste de México, en los estados de Sinaloa, Chihuahua y Durango. Fueron alrededor de 10,000 militares que fueron enviados a esa zona del país para destruir los cultivos. No se capturó a ningún líder importante de las organizaciones que en ese entonces, concentraba el liderazgo, la coalición de traficantes del estado de Sinaloa en el noroeste del país. y lo que hicieron fue trasladar su centro de operaciones de Culiacán, la capital de Sinaloa, a Guadalajara, la capital de Jalisco. Después de la Operación Cóndor en México viene la Operación Fulminante en Colombia, con un despliegue militar muy similar al de la Operación Cóndor en México y con el objetivo de destruir los cultivos de marihuana en el Atlántico colombiano, en la zona de La Guajira. 1985 en México va a ser un punto de quiebre, y va a ser un punto de quiebre muy importante que va a minar la capacidad del Estado autoritario creado después de la Revolución para contener y proteger simultáneamente a los traficantes. Esto va a ser el ocaso de la seguridad autoritaria, es decir, pasamos del ocaso de la seguridad autoritaria a la inseguridad en los inicios de lo que se ha llamado por algunos la transición democrática en México. En esta misma década de los 80 tenemos también algo muy importante para el rediseño de la política de seguridad nacional y regional de Estados Unidos, que es la Directiva de Seguridad Nacional de la Administración Reagan en 1986, que considera al tráfico de drogas como un asunto de seguridad nacional. Y esto va a tener repercusiones prácticas muy importantes que no se van a manifestar inmediatamente en los países, pero cuyas repercusiones estamos viviendo hoy en día. Es decir, cuando un problema se designa por un Estado X como de seguridad nacional y siendo las Fuerzas Armadas la institución por excelencia de salvaguarda de la seguridad nacional en sentido tradicional, pues tarde o temprano las Fuerzas Armadas iban a tener que tener un papel importante en esta lógica. En 89 la administración Bush lanza la iniciativa andina, que es el preludio de Plan Colombia, y donde la cantidad de dinero que se destinó para iniciativa andina fueron un poco más de 2.000 millones de dólares para la destrucción de cultivos de hoja de coca y destrucción de laboratorios de cocaína en la zona andina, en Colombia, Perú y Bolivia. Y en la década de los 80 podemos ver una reconfiguración muy importante, el inicio de una reconfiguración del campo de la política en México. Por primera vez la oposición política gana una gobernatura en 1989 y es el estado de Baja California. Posteriormente vendrían otras gubernaturas como la de Chihuahua, Jalisco, Distrito Federal, Michoacán, Guerrero, hasta llegar a nuestros días. Y también una reconfiguración del campo del tráfico de drogas en México, con el asiento de varias organizaciones en determinadas partes del país. No quiere decir que operaban única y exclusivamente o que operan única y exclusivamente en esa parte, sino que escogieron esas ciudades como sus santuarios. Por ejemplo, en Baja California, los hermanos Arellano Félix, originarios del estado de Sinaloa; en Chihuahua, los hermanos Carrillo Fuentes, originarios del estado de Sinaloa; en Tamaulipas, la organización que antes de la administración Salinas prácticamente no figuraba en el campo del tráfico de drogas en México, a partir de la administración Salinas se crea una especie de competencia, o de facto una competencia, para la coalición de organizaciones lideradas por traficantes sinaloenses. Es decir, se rompe la hegemonía de los sinaloenses y se crean dos grandes polos, Sinaloa y Tamaulipas. Y es bajo el liderazgo de Judicial Cárdenas, a partir de 1996, que se introducen varios elementos nuevos en el campo del tráfico de drogas en México y que son lo que están mostrando las tendencias actuales, es decir, el paramilitarismo vinculado con el tráfico de drogas al cooptar a esos militares de élite que se autodenominaron Zetas. Se introducen estrategias de tipo mafioso y como herencia del sistema de partido de Estado, el populismo, es decir, hay un cóctel explosivo que introduce la organización de Tamaulipas: paramilitarismo, estrategias mafiosas y populismo, lo que le da esa característica particular a la tendencia actual, es decir, una tendencia del campo del tráfico de drogas hacia un esquema mafioso paramilitar. Y en Sinaloa permanecen digamos, los miembros de esta coalición de bandas sinaloenses liderados por el Chapo Guzmán, Mayo Zambada, los hermanos Nacho Coronel, los hermanos Beltrán Leiva antes de la escisión. Llegamos finalmente al año 2000 con la alternancia en el poder, en el Ejecutivo Federal y algunas de las características de esta administración. Por ejemplo, la fuga del Chapo Guzmán en 2001, la presencia cada vez mayor de militares en la PGR, es un proceso que se venía dando ya desde la administración anterior, desde la administración Zedillo, bajo la cual se crean estos grupos de fuerzas especiales militares, de los cuales salen los Zetas, y capturas de algunos líderes importantes como Benjamín Arellano o Ciel Cárdenas. También ya a finales de la administración Fox, el operativo México Seguro, particularmente el Nuevo Laredo, por los índices de violencia tan fuertes, tan altos que se estaban mostrando ya, y con un despliegue también militar. Las tendencias actuales podríamos caracterizarlas como estrategias de recuperación de la autoridad del Estado. Tenemos Plan Colombia a partir del año 2000 y los resultados en términos de estos dos grandes campos, el de la economía y el de la política. Y lo que se observa en Plan Colombia, como en Afganistán, es que la lógica política no necesariamente incide en la lógica económica del mercado de las drogas ilegales. Hay una separación y una separación fuerte. En México se da una reconfiguración de coaliciones de traficantes y una lucha por la hegemonía. Es decir, pasamos de un sistema de partido de Estado donde el campo del tráfico de drogas estaba supeditado a la política, hay un resquebrajamiento del sistema de partido de Estado, hay una alternancia en el poder y hay una reconfiguración del mapa político. Hay una fragmentación de la capacidad del Estado en la etapa de la transición y de modificación y desaparición de instituciones en algunos casos. Escalamiento de la confrontación, participación de militares en la lucha antidrogas, como todos sabemos, Acuerdo Nacional para la Seguridad, la Justicia y la Legalidad, que fueron más promesas que resultados, reorganización de las policías, finalmente Iniciativa Mérida. La configuración actual del campo político, y esto es importante, es que aunque hay un presidente que es del PAN, digamos, o que fue llevado como candidato del PAN, la mayor parte de las presidencias municipales y gubernaturas en el país están dominadas por el PRI, enseguida el PAN, luego PRD y luego las alianzas recientes entre el PAN y el PRD. Violencia asociada al tráfico de drogas y partidos de gobiernos en los estados, ahí vemos dónde hay más violencia y qué partidos gobiernan y qué responsabilidad tienen también. Consumo de drogas ilegales en los estados, violencia asociada al tráfico de drogas. Tenemos, por ejemplo, el caso de Quintana Roo con alto consumo pero con poca violencia. Y en el otro extremo tenemos Chihuahua con un consumo alto y una violencia alta, ¿no? Entonces no hay una relación directa. El mapa electoral, esto si lo combinamos, y esto es importante, con las rutas del ingreso de la cocaína a México o de las zonas productoras de droga en México y de las rutas hacia el mercado estadounidense, vamos a ver por qué gobiernos pasan. Si quieren pasar por Sonora o Baja California, van a tener que pasar por gobiernos del PAN a nivel estatal, pero a nivel municipal va a haber una diferencia, porque va a haber gobiernos del PRI. Si quieren pasar por Nayarit, Durango, Chihuahua, Coahuila, van a pasar por gobiernos del PRI. Si quieren pasar por el Golfo de México, por gobiernos del PRI. Si quieren pasar por Chihuahua, Coahuila, Nuevo León y Tamaulipas, por gobiernos del PRI. Si quieren pasar por Chiapas, por gobiernos del PRD. Es decir, aquellos a quienes se va a corromper o aquellos que pueden dar protección no son necesariamente del mismo partido del presidente. Y los principales municipios costeros tenemos lo mismo. Si hay droga que se quiere introducir, que no se produce a México y se quiere introducir por el país, esos municipios están en manos de distintos partidos políticos. Lo mismo la zona fronteriza, ahí lo tienen, los azules son el PAN, los verdes el PRI y los amarillos, que son como dos, el PRD. Es decir, hay una redistribución diferencial de la posibilidad de dar protección o de estar en una posición que implique posiblemente una relación de corrupción con las organizaciones del tráfico de drogas. Configuración actual del campo del tráfico de drogas en México. Bueno, el último estudio coordinado por Peter Reuter y Franz Trautmann, lo que señala es que los mercados de drogas ilegales no están cartelizados. Contra toda lógica o contra todas aquellas notas periodísticas que hablan de cárteles todos los días, los mercados no están cartelizados. La participación de México en el mercado del tráfico de drogas ilegales, ya tenemos poco tiempo, estamos uno de los principales países cultivadores de marihuana, de amapola y de tránsito de cocaína. Las ganancias de los traficantes, hay cifras distintas según que uno revise las de la Casa Blanca, las del Departamento de Justicia, las del Departamento de Estado o las del Departamento de Seguridad Interna. Y según lo que me dicen, un nuevo estudio coordinado por Peter Reuter está mostrando cifras aún más bajas que estas. Por lo menos los estudios de Peter Reuter y compañía sí dicen cuál es su metodología, las fuentes, etcétera. Estos no. Estos son declaraciones políticas. Las ganancias de los traficantes mexicanos provenientes del mercado interno y vamos a las alternativas. Las alternativas que tiene en ese escenario la clase política mexicana es modificar de manera radical la política de drogas vigente a nivel mundial, lo cual implica una serie de negociaciones de varios países en el ámbito de Naciones Unidas y es mucho más complicado. Dejar hacer y dejar pasar, con lo cual se arriesgan a que el campo del tráfico de drogas domine el campo de la política. Asumir, como varios gobernadores, que la política antidrogas es un asunto exclusivamente federal, apostarle al fracaso de la estrategia mediante la inacción o la obstrucción y tratar de capitalizar los errores. La otra es establecer relaciones estratégicas y interés mutuo entre políticos y traficantes con la esperanza de lograr una especie de paz mafiosa y de confianza en un pacto de caballeros. El problema es que con esa estrategia se le da un reconocimiento político a los traficantes y bueno, y nos paramos con Iniciativa Mérida Plan México y lo que plantea el Comando Norte, que es aprovechar la experiencia en Irán y en Irak y en Afganistán para aplicarla en México. Entonces, muchas gracias.
Are you going to use this, Jim? Until now, our presenters have discussed things from the Mexican perspective. One set of comments towards the end of Luís Astorga's comments, I'm sure you will recall, where he talked about analysis of law enforcement and crime issues, focusing upon the regions or analyzing the regions by the issue of whether that's a place where drugs are raised for the U.S. market. Even as poor a market theorist as I can recognize that if nobody wants to buy meth, the market won't be there. In other words, the demand from the U.S. drives much of this particular issue of our discussion. And our next speaker, Judge James Gray, is a veteran judge in Southern California in the Superior Court, which is the trial court of general jurisdiction in Orange County, California. Before that, he was a federal prosecutor and a defense lawyer in the Navy JAG Corps. He's obviously seen these issues from a range of perspectives. He has been a tireless commentator on these subjects, appearing on television and radio programs and drug panels all over the country for many years, and these measure in the hundreds. And he has very, I think safe to say, strong views about what we should be doing on this side of the border. Is that safe to say? I think that's
A los de México, bienvenidos a nuestro país. Nosotros de México, nosotros de los Estados Unidos, todos somos americanos. Entonces somos hermanos. Y es una lástima a mí de nuestro gobierno siempre no ha comportado como hermanos con ustedes, y lo siento mucho. With that, I would like to ask Mr. Enrique to come forward. Thank you. 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 mostly because I have a very short amount of time. I will speak in English in order to explain myself as well as I can. As you heard from Professor McLeod, I am a former drug warrior as such. I was a Navy lawyer, Navy JAG. I was a former federal prosecutor. In fact, for a short period of time, I held the record for the largest drug prosecution in the Central District of California back in 1978, 75 kilos of heroin, 160 pounds. That was and is a lot of heroin. Do you have any concept of what the record prosecution is today in the Central District of California? 17 tons of cocaine in one place. So then I was appointed to the trial court in Orange County back in 1983, and I would watch in my own courtroom. We would churn low-level drug offenders through the system for no good purpose. We would arrest, we would convict, we would incarcerate even big-time drug dealers. And does that mean that heroin is no longer available in Santa Ana or Newport Beach? No, it doesn't mean that at all. It means that someone else has a big job opportunity, an employment opportunity, and within about an hour and a half, they are selling fully as much heroin or whatever as the other person was. So there comes a time when you must speak out and recognize the truth. And the truth here is, in my opinion, that drug prohibition is the biggest failed policy in the history of the United States of America, second only to slavery. It is not working from my standpoint, and it will never work. So I did something very unusual as a sitting trial court judge. Back in 1992, I held a press conference stating what was very obvious to me. We had to change our approach because what we were doing was not working. And I've been speaking about it ever since. That was 18 years ago. But I'm going to include you. Forget my views, forget my opinions, forget my experience. Use your own. How many of you people here feel that we in the United States of America are in better shape today than we were 5 years ago with regard to this critical issue of drug abuse and all of the crime and misery that goes with it? I see no hands, and that is completely consistent with every group that I speak with. Political group, service club, religious group, it doesn't matter. We all realize what we're doing is not working. Let me ask you, how many of you here, using your own experience, believe that you in Mexico are in better shape today than you were 5 years ago with regard to the critical issue of drug use and abuse and all of the crime and misery that goes with it? I see no hands, completely consistent with that. What's the first understanding when you come to that realization? And that is, we're not going to be in any better shape next year than we're in today unless we change our approach. Fair enough? The rule of law. Professor McLeod, I'm going to disagree with you. It is not incredibly complicated. It's really pretty straightforward, this entire area. We are facing two substantial problems, your country and mine. One is drug harms, the problems because of the drugs themselves. Yes, they can be dangerous. Yes, they can be harmful. Yes, they can be addictive. And anything people are going to say on those areas, I will probably agree. But the second problem we're facing is drug money problems. And I stand here without fear of contradiction, saying that drug money problems are far worse than the drug problems will ever be. And these we can deal with. The rule of law, there's a cardinal rule of human nature that governs this entire area, which is, as soon as you prohibit a substance, you give up all of your ability to have anything whatsoever to say about it, whatsoever. Its quantity, its quality, place of sale, age restrictions, price. You have nothing to say about those at all. You give up all of those completely important situations to the drug dealers, to the thugs, to the Mexican drug cartels, Soon as I really start getting in motion, things happen. You can hear things are exploding all over the place. He's a friend of mine. He was right on cue. It's true, folks. As soon as you prohibit something, you give up all of your ability to have anything whatsoever to say about it. Rule of law, there is no rule of law and never will be except that is imposed by the drug dealers. We in the United States of America have an enormous problem with juvenile gangs. Our juvenile gangs' primary source of funding is what? The sale of illegal drugs. If we really wanted to make great headway with regard to that issue, we would repeal drug prohibition. Today, we have as many drugs in our country as we can possibly use. It is the truth that we will never run out of people willing to take even large criminal justice risks or even face violence to sell small amounts of drugs for large amounts of money. As long as we have someone figuratively standing on a street corner in any city or pueblo in the United States with $100 in his or her hand, there will be somebody that will supply them with $100 worth of drugs. It will always be the truth. So we must recognize that fact. The fact is that it's okay to discuss drug policy. Just because we would change our approach does not mean we condone drug usage. Doesn't mean that at all. It just means that there's got to be a better way. And look at alcohol prohibition, the experience in our country. When we finally came to our senses and repealed alcohol prohibition, at least Al Capone and people like him were no longer in the alcohol distribution business. Remember the quality control problems that we had during alcohol prohibition with what I called the bathtub gin. They went away. We didn't have, for example, Coors beer shooting the distributors of Budweiser if they had a problem. They would bring them to me as a judge, and we would deal with them peacefully. But if one drug cartel in Mexico has distribution problems with another drug cartel, what happens? Ask Ciudad Juarez. They take guns, and my thugs will beat up your thugs, and my people will kill your people, and a lot of other innocent people along the way. The head of the DEA of the United States of America, several years ago now, was quoted as saying that at any one time, there are 200 tons of cocaine warehoused in Mexico within 3 miles of our border, simply waiting for there to be a scarcity in Albuquerque or Chicago or Miami or somewhere else so that they would smuggle them in. I tell you from Mexico, you must legalize these drugs and bring them under the law, and it will not make any difference at all with regard to our country and the availability of drugs. We now have more than we can take anyway. And in fact, there is an arrogance about our government coming to you in Mexico and getting upset with you in Mexico that you're not doing enough to solve our drug problems. Shame on us. And the truth, again, is the irony. You could bulldoze Colombia, obliterate it from the face of the earth. You could take Ecuador and Peru with it if you wanted to, and it wouldn't make any difference at all with regard to our drug problems here. Why? Because as long as the demand is here, the demand will be met. And if it's not met by Colombia, Ecuador, and Peru, it'll be met by Nigeria, or Thailand, or Burma, Myanmar Republic, or California. Do you know what the largest cash crop is today in the state of California? It is marijuana. Number 2 is grapes, by the way. It's the money. It's the money. I was in the Navy in Guam, the island of Guam out in the Pacific Ocean. I got there, it began in 1972. Shortly after I was there, 5 or 6 months after I was there, we had headlines in our local paper that there was a homicide, a murder in Guam. And people were really concerned. How can this happen in our island? They hadn't had any homicides since the end of the Second World War. They were looking around, why could this happen to our state or our place? And you know what happened? With time, they determined that it was related to the sale of drugs, because that was around 1972, the height of the Vietnamese War, and there were a lot of airplanes coming in, our military airplanes from Thailand mostly, or from Vietnam, bringing drugs, smuggling drugs into Guam. And by the time I left, I was there for 2.5 years, there was a homicide at least on the average of once a month, all drug-related. That is my little experience with regard to watching the increase in violence because of the drug, no, not because of the drugs, because of the drug money. And you can look at Mexico and see what's happening there too. And by the way, and I applaud Mr. President Calderon, his mind, his heart is in the right place, he's trying. Of course, now he's getting this Mérida initiative, and we're throwing more money at it, like we're good at that. But you look at the problem. The harder you turn those screws, the harder you enforce these laws. Now there's less cash in Mexico from the fewer dollars, but there's still the drug traffic going on. So do you know how the generals in the drug war, or the cartels, are paying their lieutenants? They're now paying them in drugs, aren't they? They used to pay them in dollars, now they pay them in drugs. That's a major problem. Why? Because if you're one of these drug lieutenants getting paid in drugs, you want the money, so now they've started to sell more of these drugs in Mexico. Isn't that true? You didn't used to have a particular drug problem in Mexico that I'm aware of. Now you do, because how do you do that? I want to sell drugs in your community, so I make my money. And be careful, because the AIDS problem will follow shortly thereafter. These problems with increased usage of drugs in Mexico and the AIDS problem that can and will come are caused by drug money, and it's our drug money that's doing it. I hope this isn't just another conference. We talk about this a whole lot. I've been doing this for 18 years. And yes, you know, we can put more money into it and we can all get together and everything else. But it's okay to discuss drug policy throughout the rest of this conference. Understand that the situation will not get better until we change our approach. And in this, you can consider the experience of Holland. Holland decriminalized all drugs back in the early 1970s, decades ago. And the Minister of Health of Holland held a press conference. I quote it in my first book, Why Our Drug Laws Have Failed. And he said, we only have half the marijuana usage, for example, in our country per capita as you do in the United States of America. Listen to this, both for adults and for teenagers. Half the marijuana consumption in Holland, both for adults and for teenagers. And he went on to explain why. You know what he said? We have succeeded in making pot boring. Now, we glamorize it by making it illegal, and we also glamorize it by having an absolutely obscene profit motive to get you, your neighbors, and your children using this stuff. Then let's look at Portugal. It's almost unknown in our country, but Portugal decriminalized all drugs back in 2001. And last year, the Cato Institute studied, as a result of a study of all of the statistics between 2001 and 2007, issued a report. And you know what they found? Drug usage in Portugal remained pretty much the same. If anything, it went down about 0.5 percentage point. So the whole idea that, oh, if we were to change our approach, we'd become a nation of drug zombies or something silly like that, which I think is insulting. Nevertheless, it didn't happen in Portugal, but problem drug usage went down by 50%. Problem drug usage went down by 50%. And you know why? Because people there in Portugal that were having drug problems, they all know who they are, were afraid before. They were afraid of their own government. They would not bring their problems to the government. Why? Because if they did, the government would punish them. Plus, the government was spending so much money on investigation, prosecution, incarceration, they didn't have any money left for drug treatment. But now that they had decriminalized the drugs, the people were coming to the government with their problems, and the government was spending money on drug treatment, and they have half the problems there with drug usage that they did before. There's a message there. They should go farther, because in Holland and in Portugal, it's still illegal to supply the supplier, in effect. They should go farther. We in California pretty much lead the country. There's lots of things that we do, and as I say, not only always joking, some of them are good. But in California, we have Proposition 19 on the ballot this coming November, just in 5 weeks. And it would treat marijuana like alcohol. It will allow adults over the age of 21 to possess up to an ounce of marijuana and even grow their own if they want to under various programs. I hope it passes. Today, we have our juvenile gangs, like I said, using the sale of marijuana and other drugs as a recruiting tool. Hey, you want to be part of the action? Come join our juvenile gang. And of course, we might as well take out billboards for a lot of our young people, just like you in Mexico. Hey, if you want to make some money, you can never make nearly as much money at doing anything you can as selling drugs. Have you seen the equivalent where you have young people, teenagers, go to a party on Friday night, start talking to a guy who's one of their colleagues or whatever, friends, who's selling drugs? And the drug seller will look at him and say, hey, you're working now, aren't you? Yes. How much money did you make last week? Oh, I made $150. $150? I can make 5 times that much in an afternoon selling drugs, and he's right. It is corrupting our youth. Ask yourself this question: how much corruption can you buy for $1 million in cash? And the answer is quite a bit. And $1 million in cash is nothing with regard to drug cartels and drug money. We only seize about 5 to 10% of all of the illegal drugs in our society. You've already heard from other speakers that in Mexico, yes, you've seized, what, $300 million or something like that? This is multi-billions, tens of billions of dollars. We only seize 5 to 10%. We couldn't do it worse if we tried. It's okay to discuss drug policy, and it is time for your country and ours to listen to people like Luís over here, Astorga, who's telling the truth. Tiene razón. It's okay to discuss drug policy, and just because we do does not mean we condone drug abuse. I actually have a book in the back. I'd be happy to discusses this. I'd be happy to sign it, and I appreciate the opportunity of sharing these thoughts with you, and I look forward to your questions. Thank you. Buena suerte a todos.
I was remiss in not mentioning, I believe the book that Judge Gray has back is Why Our Drug Laws Have Failed. Is that the book? It's your new book? Yeah, these got voters, they have voters handbook? Okay. So, judges who write books, they're hard to keep up with. We have time now, a few minutes for questions and answers. If you want to ask a question, you'll need to come up and approach the microphone so your words can be translated by our simultaneous translator. So if anyone has questions, please come on up and don't be shy. Everybody wants to hear you and your questions. While we wait, no, come on, folks. While we're waiting for this brave gentleman, I will say, in response to our last 2 speakers, it was interesting hearing Luís Astorga talk about the month and a half in the 1940s when Mexico attempted what Judge Gray just proposed and then relented to political pressure. And in response to what Judge Gray was just saying about prohibition and drug use, there's an emerging body of research about our alcohol prohibition effort in the first decades of the 20th century. And most of the data now suggests, though it's, data about black markets like drugs and illegal alcohol are notoriously unreliable because it's illegal and people tend not to talk honestly about it. But all of the data seems to suggest that 10 years into prohibition of alcohol, there was a much larger quantity of alcohol being used in this country than there was before prohibition. So I think that would be the reverse of what Judge Gray was just talking about. I mean, it's the same thought, but prohibition increased alcohol use as opposed to decriminalization reducing drug use. Sir, would you go ahead with your question?
Sí, gracias. Bueno, antes que nada los felicitamos a todos. Muy interesantes las intervenciones, pero Judge Jim Gray, yo lo felicito en lo personal por la claridad de la intervención. Como mexicano ahorita y en México se está discutiendo muchísimo, no solamente siguiendo la discusión de California, sino se está realmente analizando las ventajas y desventajas de despenalizar las drogas o quitar la prohibición de las drogas. Y hay una discusión muy intensa, pero la pregunta es, dentro de su experiencia y perspectiva de más de 18 años de gritar la verdad y decir, es momento de desprohibir o despenalizar las drogas, claro, bajo un procedimiento, bajo una lógica. ¿Cuál es en verdad la razón de fondo que Estados Unidos tiene frente a la coordinación o comunicación de estos temas en su experiencia con México? ¿Es un tema estrictamente económico? ¿Es un tema de falta de voluntad política? ¿Es un tema de falta de interés institucional? ¿O es un tema estrictamente de política de salud? Pero bueno, si la lógica y la realidad nos exigen despenalizarla, ¿por qué no está sucediendo esto, señor juez?
Jim and Judge Gray, if you'll start, and then any of the other panelists, please just jump in after he's done.
Thank you for your comments. I have no particular expertise as to answer the question. I am ashamed to say that we're being consistent with Mexico. We talk with Mexico the same way we talk with ourselves. There is a law, a federal law, with regard to our Office of National Drug Control Policy, otherwise known as the Drug Czar, that literally that law precludes, keeps him from discussing even the issue of decriminalization. They can't even talk about it. They can't support, like Proposition 19. So we're fighting, in a lot of ways, decades of rhetoric. We're all kind of raised the same way to equate heroin, for example, with evil, with bad, with prison. And so we have to get the word out that no, it's not a good thing to do. I've never heard anyone say that being a heroin addict is a good thing. But we've got to address that problem from a medical standpoint instead of a criminal justice standpoint, and hold people accountable for what they do instead of what they put into their bodies. Otherwise, it's just a question of time. There is absolutely no question in my mind that eventually we will, in effect, strictly regulate and control marijuana and even some of these other drugs. It's just a question of when. But the untold damage and carnage and violence and luring our children into the lifestyle that we're trying to keep away from them will get so much worse until we finally come to that sense and do that. But thank you for your question.
Does anyone else care to comment? Okay, our next questioner.
Hi, my name is Leo Beletsky. I'm an assistant professor at UCSD School of Medicine, and my division does a lot of work on drug-related harms in the cross-border region. I just wanted to sort of comment and probably two comments. One is, I think that it's very much key to look at the sort of the evidence, to take an evidence-based approach to drug policy that Judge Gray was advocating, and I think that building capacity to do the kind of research that builds such an evidence base should be a key focus of the binational efforts, such as this conference and other efforts. And another comment that I wanted to emphasize is that I think the question of law enforcement and sort of the gap between the law in the books and the law in the streets should be emphasized in this larger discussion of the rule of law, because even the best reforms often are not reflected on the actual situation on the ground, and especially in places where the governance structure doesn't support strong police management. That's a really key question to also focus our attention on. Thank you.
Thank you. I'm going to treat those as two questions responding to comments various presenters make. Does anyone want to respond? I mean, talking about the rule of law or the research, Jeff, or any responses to that? Or no?
Well, I mean, it's only what I hear is a reflection of my basic position in a completely different discipline, and that might.
So he was exactly right.
Spot on.
Yeah, that's right. Sir.
My question is connected to his.
Can you speak into the microphone so directly?
Right. My question is connected to the previous question. My name is Howard Campbell. I'm an anthropologist at the University of Texas at El Paso, and I do research in Ciudad Juarez. And I thought all of the panelists made valuable comments and provided insight into these issues. But I wanted to ask a very fundamental, sort of basic, practical question. What could we do in the short run in the United States and Mexico to try to lessen the violence in a place like Juarez?
Thank you.
From my perspective, you can talk to anybody you know that can vote in California and encourage them to support Proposition 19. By the way, I was at UTEP a little while ago on that convention, and I applaud your city council for its resolution. But it's a very large problem. I have spoken myself with 2 sitting congressmen from Orange County in California, and they tell me, you know, pretty much many people in Washington realize that the war on drugs is not winnable, but it's eminently fundable, and the government is addicted to the drug war funding. So basically it comes down to it, money on both sides.
And from the Mexican perspective, is there?
Bueno, desde el punto de vista de la autoridad mexicana, creo que Juárez debe emprender un esfuerzo similar a lo que ha sucedido, por ejemplo, en Tijuana, donde puede hablarse de un éxito relativo en cuanto a la coordinación entre las autoridades locales con las autoridades federales, la coordinación entre las dos naciones, la confianza, el intercambio de información e incluso el restablecimiento del tejido social. Porque la situación en Juárez hoy es la violencia en Juárez es hoy de tal nivel que incluso tenemos ciertos datos que pueden acreditar que si el gobierno tomara hoy la decisión de retirarse absolutamente del combate a las drogas en Ciudad Juárez, la violencia se mantendría prácticamente igual. Ya por el daño que ha sufrido la sociedad, por la violencia que está ya tan conectada incluso con las pandillas o con miembros de las pandillas que son ciudadanos de ambos países, entonces viven de un lado de la frontera y delinquen del otro lado. Entonces creo que ahí es un esfuerzo que tiene que pasar por todos los ámbitos, desde el ámbito de la prevención hasta el ámbito del restablecimiento del tejido social.
We have time for one more question.
Sí.
So if you could proceed, please.
Yo soy de la Ciudad de México, del Poder Judicial Federal, y de acuerdo a lo que han expresado los ponentes, efectivamente, como dice el doctor Astorga, en México tenemos una serie de cárteles o líderes que son los que llevan a cabo todas estas conductas delictivas y que hacen que haya el narcotráfico y sobre todo que se introduzca la droga aquí en Estados Unidos. Sin embargo, yo siempre he tenido la inquietud, y ahora que está también aquí el juez, de que si nos pudiera señalar, porque en México pues siempre tenemos de que nosotros resolvemos asuntos relativos a cárteles, a líderes, así como lo señaló el doctor Astorga, y sin embargo, aquí en Estados Unidos no tenemos conocimiento de que ustedes también tengan cárteles, tengan líderes que son los que reciben la droga, no solamente de México, sino de otros países. Entonces, mi inquietud es esto, y usted como juzgador seguramente debe de conocer este tema. Muchas gracias.
Judge Greer, I think that's directed at you.
I worry about this all the time. Just what was happening in my own courtroom. We were ruining people's lives. The United States of America leads the world in putting people in prison. And here, that's both per capita as well as sheer numbers. And I assure you that here, we're #1 does not make me proud. The United States has 5% of the world's population and 25% of the prisoners. So it's not that we're not trying, and it's not the fault of the police, it's the problem that we just have the wrong system. We are working against ourselves, and we are working against Mexico and Afghanistan and pretty much Colombia or any other of these places. So again, it's not that difficult. We have 2 problems. Let's address the second problem and take the money out of it. Then we can all join forces and address the first problem of the drug harms. But we'll never have a society without drugs in it. Every society in the history of mankind has always had some form of mind-altering, sometimes addicting substance to use. So instead of moralizing about it, let's start managing the problem and bringing the healthcare community in line with what they can do, which is the use of drugs, and bring the criminal justice system in line as to people's conduct, and we'll begin to make a lot of progress.
I'm going to stop us right there. We're at time, maybe a minute or two over. This will be the first time in my life I've actually kept the train running on time. I want to thank our panel for just tremendous presentations and really great beginning to our conference. Thank you.